Hello, everybody.
All right, we will now go back over to the Nisqually jail. And ma'am, what's your name, please?
Haley Lovell.
All right, Miss Lovell. Good afternoon.
Hi, Your Honor.
And Miss Lovell, today you're in court because a warrant was served on you. You had previously missed your arraignment. We'll go ahead and take care of that now. The charges against you are theft in the 3rd degree and unlawful possession of a controlled substance. And the city of Tumwater alleges that those offenses occurred on March 30th of 2024. Some more? Are you handling Miss Lovell's case?
I am, Your Honor. Good afternoon. So, Your Honor, I spoke with Ms. Lovell by phone over the lunch hour. It looks like probable cause was obviously established previously for the warrant to be issued. I would just ask the court to enter a plea of not guilty to both charges and to appoint my office for Ms. Lovell. She is, I believe, she is not working and has pretty precarious housing situation. So while I neglected to ask directly about government benefits, I think she likely would. She is indigent, Your Honor, and would ask for us to be appointed. I do have good contact information, not for Ms. Lovell specifically, but for her boyfriend and her parents. She has a phone, but has not memorized the number yet. I gave her contact info for my office as well as Mr. Pazderka specifically, given this is a Tumwater case, which I could be wrong, but just in anticipation. So she will provide us with her phone number once when she is able to.
Okay. All right, Ms. Lovell, I'll enter your plea of not guilty to both of those charges and appoint the public defender to represent you in this case. All right, and what's going to be the city's recommendation on conditions?
Your Honor, there's no objection to a PR release. We're going to be asking for no new law violations and no alcohol, marijuana, non-prescribed drugs, no bars or taverns, and then stay away from the Walmart on Little Rock Road in Tumwater.
Any objection to any of those conditions?
No objection, Your Honor.
All right, Ms. Lovell, I'll release you today on your personal recognizance while the case is pending. Don't violate the law. No bars or taverns, no alcohol, marijuana, or non-prescribed drugs, and don't go to the Walmart, okay?
Yes, sir.
All right, I'm going to give you a date to come back to court for your pretrial hearing.
Yes, sir.
Okay, that's going to be on August 27th at 10:30.
22nd?
August 27th. You're going to get a written piece of paper with that information on it in just a minute.
Yes, sir.
Okay, so Ms. Lovell, you can let the corrections officer know you're all done.
Thank you, Your Honor.
You're welcome.
Have a good day.
And we're going to go back over to the county jail, but I think we may be waiting for counsel.
That would be Mr. O'Connor, Your Honor.
Okay. All right, and sir, at the county jail, did they show you how to turn on the sound over there? Okay, there we go. Looks like the microphone is on. Okay, and your name, please?
Lord State Master Robert Jesse Hill.
Mr. Hill, okay. Thank you. Mr. Hill, today you're in court for your arraignment on the harassment charge that we discussed before. I believe we reset this earlier at your request. Mr. O'Connor, are you representing Mr. Hill for this hearing?
I'm not, Your Honor. My capacity here today is when the court wants to address the appointment of counsel. I have a position.
Okay. All right. And I don't know that Mr. Hill has asked for counsel or if we determined that previously.
I don't believe he completed an agency screening form. That's my understanding.
I mentioned Gideon versus Wainwright 2 weeks ago and Argersinger versus Hamlin.
Okay. All right. So this is one of those cases where there are charges pending simultaneously in Superior Court and District Court, which I think has caused a little bit of confusion here. But from looking at the record, I can see that the Superior Court has ordered, as of July 21st, a competency evaluation. This is the second, I believe, hearing that I've had with Mr. Hill. And it certainly seems obvious to me why competency evaluation would be ordered. And it seems to me to be a reasonable and prudent thing to do to order one in this case as well.
What's the
Although-
basis? Are you going to give the basis?
Yeah, Mr. Hill, let me just ask you, I'm gonna ask you just this one time to don't interrupt and talk over me. So it'll just be the one time. All right. After that, your hearing will be terminated and we'll try again another day. Okay. Do you understand that?
I acknowledge what you're saying. I don't understand it.
Okay.
You
And
haven't
then
set the rules for
I will tell you when it's your turn to talk. Okay. And then you'll know.
acknowledged.
Okay. I did not see a date set for a competency hearing yet, but I'll check again. It may just not have been entered in the record yet. All right, so before we go any further with the issue of appointment of counsel, Mr. O'Connor, you said you had a position on your office being appointed in this case.
I do, Your Honor. I don't know if Mr. Hill is requesting counsel in this case. I can tell the court on his other matter. I appeared on the 21st in front of Judge Wilson. Judge Wilson made that decision sua sponte to enter that order. I believe there's a hearing set for August 4th to review. DSHS did reach out to our office in scheduling that evaluation. We did indicate to DSHS the current status of Mr. Hill's case as in terms of representation in Superior Court, as he is pro se without standby counsel, and that's the current status in that matter. So I'll only address that sort of the procedure of that matter, and the court's now aware that that judicial officer's finding, and then Mr. Hill can speak for himself again on this case, whether or not he's requesting counsel be appointed. I'm going to oppose any such appointment of counsel and happy to state my reasons. But given the posture of that finding, I understand the court has a decision to make today.
Okay, and I do see now that there is a hearing scheduled in Superior Court for August 4th. They've just noted it as an evidentiary hearing, but it makes sense that it's actually a competency hearing. Okay. All right, and I was on the point of saying that it appeared to me that based on my prior interaction with Mr. Hill and today's interaction with Mr. Hill, that he is struggling to behave appropriately to the court proceedings. In addition to that, he does not appear to have a grasp of the charges pending against him and what they mean. And I don't know that a further conversation is going to shed any light on that with regard to his capacity to proceed, but I'm going to try that right now. So I'm going to ask you a couple of questions, Mr. Hill, just to get us oriented here. First of all, I know we told you earlier about your rights, and one of those was the right to have an attorney represent you in this case at all stages. Did you give any thought to that, and have you decided if you want an attorney?
Well, what I've done is read a little bit of the chapter 1077, and at the very beginning in section 20, it says that a defender shall be appointed to any indigent defendant specifically for a 1077 evaluation process, completely separate and independent for an attorney from the case. Now, Max Deutschman hasn't been in touch with me the last day or two. I haven't been able to talk to him. He's on record as an attorney of record. He's not here. So I guess you're going to have to appoint through TCPD or O'Connor somebody that can show up and be right next to me in this room before you do any 1077. Because I have a right to not have to talk. I'm talking because I'm forced to. Because there is no defender here. There's a couple defenders out there, not in this room. Now, do you want to spend 5 minutes recess reading all of section 20 and a few of the listed LexisNexis notes at the bottom about the requirement for this hearing, if you're going to intend on do a 1077 order, for presence of public defender or not?
All right. Well, Mr. Hill, I haven't gotten to the point of deciding about a competency evaluation. Starting with the question I asked just a minute ago, whether you had given any thought to whether you want a lawyer to represent you in this case.
I do, and I thought Max Deutschman was going to be here. He's told me that I drafted the notice of appearance for him because he was busy. He dropped by and signed it. It's been filed. He's not here. So either he gets tracked down, or a normal American Washington State Bar Association attorney gets appointed. The choice is in your hands.
All right. So I've seen a pleading filed by Mr. Hill that purports to be by an attorney by the name of Deutschman, who quick research shows does not exist in the state of Washington. I think that this just confirms my earlier suspicion that Mr. Hill does need a competency evaluation, and I am going to order one. So, Mr. O'Connor, you don't believe your office should be appointed as counsel for Mr. Hill?
Your Honor, again, on Mr. Hill's other Superior Court matter, the court went through the colloquy and granted his request, which he filed multiple motions requesting in that matter to proceed pro se. The judicial officer in Superior Court made that finding, and that's his current status. We didn't address standby counsel at the hearing on the 21st. The issue was broached, but no decision was made. I'm going to oppose standby counsel, and that's based on Mr. Hill's prior appointment of 3 different counsel in Superior Court. Our office has a legal conflict of interest in appointing a trial attorney from my office to represent Mr. Hill. And this isn't personal with Mr. Hill. I've known Mr. Hill for 20 years. However, the 3 prior attorneys, which combined for about 80 years worth of experience, all needed to withdraw from their representation based on conduct of Mr. Hill. And I believe it's extreme dilatory, as the case law would point out, that it's a constitutional right. It's a constitutional right I wake up every morning believing in, and I don't oppose standby counsel willy-nilly. However, I have zero confidence that any attorney, a conflict attorney, I don't have much confidence that I can even find an attorney that's willing to work with Mr. Hill, and B, even if I did, that the result wouldn't be the same. So again, that's my position in that matter. I believe it would be the same position in this matter.
Okay. I understand. I appreciate that explanation. Okay. So before I can allow Mr. Hill to represent himself, I've got to be confident that he does that after proper advisement and with a knowing and voluntary waiver of his right to counsel, which I am not going to accept until I have a determination that Mr. Hill is actually competent to proceed. So as I said before, the first order of business is I'm ordering a competency evaluation. That's going to be done to determine whether Mr. Hill can proceed at all. And I'm going to set a competency hearing, and we may as well do that directly after the hearing in Superior Court. So let's set that for August 5th. At 1:30. Now, Mr. Fortunato, you're not going to order a separate competency evaluation from the one that Superior Court has ordered. We're going to use the same evaluation. That makes more sense than consuming the Western State Hospital's resources twice for the same person who's in the same jurisdiction's custody, even though his cases are split out between district and Superior Court. So I'm going to put the burden on the state to secure from the Superior Court file the competency evaluation when it's available and file it in this court.
Understood. Thank you, Your Honor.
I'm also going to appoint counsel for Mr. Hill, and for the reasons that Mr. O'Connor just said, will be a conflict attorney from a different, from other than the Thurston County Public Defender's Office. And I will tell you, Mr. Hill, that whoever that person is who's assigned to represent you for the competency hearing, if they're, I don't know exactly how to characterize it, but if they're unable to represent you for reasons of your behavior, you will not have an attorney after that.
All right, can I ask a point of clarification? I do believe I heard Mr. Hill requesting the appointment of counsel in this matter.
Yeah, and
But
I am absolutely going to appoint counsel for him because he's entitled to it. And I'm confident that he's able to knowingly waive his right to counsel.
understood. I think the courts, just to clarify the court's language, that counsel is not representing him at the Superior Court competency evaluation. So the expectation from Mr. Hill to participate in that evaluation is status quo, which is that order was ordered in a Superior Court matter where he represents himself. Judge Wilson did not order the appointment of counsel, so he will not have counsel present based on that court's finding for his 1077 evaluation.
Yeah, that is true. The Superior Court is the court that ordered the evaluation to be conducted. So it'll be done pursuant to Judge Wilson's order in Superior Court.
Thank you, Your Honor.
Okay. All right, Mr. Hill, that's all for today. We're going to see you back in District Court on August 5th.
I have one item.
Sure, go ahead, Mr. Hill.
So my understanding of the True Blood settlement is that on the 14th day of incarceration, in order to not violate due process, the state shall release such a defendant awaiting evaluation. So I'm expecting to be released at some point on Monday. I will be out of custody to attend the 1:30 hearing, in my belief, the following day for this court.
Yeah, that could very well be. You're not held in custody on this particular case. So if you're released on your other hold, then you are correct. You would be attending this hearing out of custody.
What room? What courtroom?
That will be in courtroom 2 in District Court. That'll be on your paperwork.
Building 3.
All right. So that'll conclude your hearing for today. And now I'm going to cut away over to the Nisqually Jail again. And ma'am, can you tell me your name, please?
Pamela DeCray-Corn.
Okay, Ms. Ducray-Corn. Good afternoon. And today you're here in court for your arraignment on a charge of simple assault that the city of Lacey alleges occurred on July 29th. Mr. Sabian?
Yes, Your Honor, I would like to enter a plea of not guilty.
Be safe, be well, sleep sweet, and much love.